Of our autumn series, as I said. I think there's a problem with my sharing screen there. Hopefully back on. So yes, first of the autumn program. The other first today is it's probably the first seminar I've done in the last 18 months that has not had a title that has COVID somewhere in the title or linked to it, or furlough or something associated with the pandemic. Obviously, we're never getting, that's always in the back of our minds, and there obviously is an impact on performance management processes with the pandemic and with a number of people remote working still, and that that might continue indefinitely. So we'll be conscious of that, and we will bear that in mind when we go through today. But strictly speaking, we're not going to look at this being any different, and the still relevant, I think, will come in to both into a COVID discussion and generally into performance management. So start things off today. Why manage performance? And I thought I'd let you in a little trade secret here. When we are putting together a seminar, we often sit down preparing our autumn seminar. We sit in a big room or with all the team, and we throw ideas out into what we want to present. So that's either things that we are dealing with on a day-to-day basis. It's things that are in the news, it's new legislation, new case law, and then we'll put a seminar on the back of that. This falls into the former category of something actually that we're getting a lot of issues with at the moment. So when we put together a slide, the little trade secret is actually what we first do is look what we've presented before. And we go back, and I went back and had a look at the seminar I did in 2018, and shock horror, I've got the first slide from that, and I thought I'd share that with you. So whilst it goes without saying, obviously the rest of this presentation is absolutely bespoke and new for today, I've left this slide in, and I've left it in for a reason, because I think this is absolutely relevant to the question that we've proposed at the start of the presentation today. Is performance management still relevant? And back in 2018, I offered these thoughts as to why would you manage performance? And we came up with three, which was productivity, morale, and claim. So I thought I'd look at those and really question performance management. Does this really result in increased productivity? Does it really result in increased morale? The claims point we'll touch on in a minute. And what I would be really important to stress as a starting point, when I am talking about performance management today, I really want to focus on the legal aspect of performance management. So what I'm not talking about today is welfare. I'm not talking about remuneration. I'm not talking about benefits. I'm not talking about flexibility and things that impact on performance and absolutely should come part of any culture and management process in the workplace. I'm really looking for at an issue is when you have an issue with performance or an employee who is demonstrating poor performance, is a formal performance management process relevant? And that's why I wanted to look back at these three areas. So in productivity, what we said back in 2018 is that keeping an eye on performance makes a workplace more productive, because employees have an eye on that, and they have an eye on whether their performance is being measured and reviewed, and that in some way makes them maintain their performance. Morale, again, was what the musings we put forward in 2018 was in essence, well, if you don't look at performance management, the morale will drop because either people aren't being brought up on their performance, and people who are performing well will see that, and their morale will drop, or that people who are engaged in performance management feel rewarded and feel that when their performance improves, that they are being that is being recognised. And those two things I would question, both through personal experience of managing teams, but more importantly from a legal aspect. These cases are things that I deal with every day of the week. And I think it is extremely rare that if you start a formal performance management, that productivity increases, or that individual's morale is improved, or indeed the morale of that workplace. To question someone's performance, I find is often the most tricky thing to deal with in a HR environment with an individual. To question not necessarily their conduct, not necessarily the job they're doing, but you are underperforming. You are in what we're going to talk about in a minute. You are incapable of doing that job, and that is very emotive. And therefore, I would always question formal performance management. Is this the right thing? And if it is, when are you doing it, and why? My general view is that of those 3 bullet points that we put forward in 2018, the claims is probably the most relevant. And why you performance manage is often to hopefully reduce a claims liability for your organization. So that's what I want to talk about in more detail. So again, very simple question. Why do it? What a positive way to start the seminar. So why do it? And again, I think I've got 2 relatively blunt answers. You've got no choice, or there is no better option. So again, what we are looking at here is not that softer side, not the well-being, not the culture, not the remuneration of staff, but when we have a chronically underperforming member of staff, should you look at performance management? And my potentially quite controversial view is that you should only do that if you have no choice and you have no better option to go for. There is no better option. Again, I've put that little caveat, maybe there is, and we'll come on to that in due course. What are we talking about in practice? Where we are often looking, and we'll talk about length of service throughout today, and employees' length of service and the impact that has. The classic scenario here is we're dealing with a chronic underperforming employee. He or she will have over 2 years of service at the company, and that performance is having a negative impact on either their team or the organization as a whole. What we often would look at, and I would say to look at, is, well, what are their alternatives? Is there any other way we can potentially manage this person out of the organization? And if not, we may have to go back to performance management. Why is that my view? We will explore. And the real focus of today, therefore, is if you are faced with that scenario, that we don't have many other options, you've got a chronically underperforming employee that you would like to manage out of the business. Well, how do you do that right? And that is what the focus of today is going to be. So where that starts, and apologies right off on this slide, because we are going back to Law 101, and I appreciate, because I know the vast majority of you in the audience today will be absolutely aware of the 5 fair reasons for dismissal, and will not need me to tell you what they are. But for anyone who obviously isn't aware, and for completeness, where we are dealing with here is we are in the world of unfair dismissal, and we are in the reasons of fair dismissals under the Employment Rights Act. So obviously, as you can see on the screen, there are 5: conduct, capability, redundancy, some of the substantial reason, call that SOSR often, or the last one, again, it covers by a few names. We call it contravention of statute. Some people call it illegality, which is often a reason, probably the least that we use in practice. So obviously, as it is in bold, what we are focusing on today is the subject of capability, which is one of the 5 reasons for dismissal. Under the Employment Rights Act, capability actually comes in 2 forms. So that is capability assessed in reference to someone's skill, aptitude, health, or any physical or mental quality. So generally, again, you're splitting that subheading, that bullet point, into 2 main areas that we deal with. Really, performance management being someone's skill and aptitude, really, and someone's health, with generally being in ill health dismissal. So they're your 2 main capability dismissals. There is actually a third that is often overlooked, which is someone's qualification. Generally meaning any degree, diploma, other academic, technical, or professional qualifications. So you can actually, and again, rarely used in practice, but look to dismiss someone on the grounds of their qualification. So that, again, can either be an academic qualification. So as myself, as a solicitor, obviously hold a practicing certificate. If I am then barred or no longer hold a practicing certificate, I actually can be dismissed on the grounds of my qualification. Equally, other elements, driving license being a classic one, or a truck lift driver, for example. Someone who loses their license, no longer has that capability, doesn't keep that qualification up to standard. We can look to dismiss on the grounds of their qualification. Still within a capability dismissal, still a process needs to be followed. So again, something that is often overlooked, but not the focus of today, as we are talking about performance management. So we are talking about capability dismissals. Where we started and often where we will end is looking at other ways. And obviously my statement of, well, what else can we do? And then we will look fleetingly at other potential fair reasons for dismissal, generally conduct, redundancy being the classic 2. So, process. So to talk, whenever we're talking about a performance management capability issue, what we first need to look at is fair dismissals. So when we are judging whether a dismissal will be fair, what the courts and tribunals will look at is the reasonableness of the employer's decision and the procedure followed. So what the tribunal will need to be satisfied is that the employer had an honest belief that individual was incapable. And with regard to the overall question of reasonableness, the tribunal will look and consider whether management has failed to discharge its own responsibilities towards the employee. So they are your 3 keys in any procedure that we're looking at, which we'll go into more detail. But again, starting points: honest belief in capability. So that is the performance. Is there a issue with someone's performance? Reasonableness, which a lot of you will be familiar with, general test in employment law. And then the key 3rd one, which will be different from issues that we deal with often in conduct, that management will be scrutinized to see whether that duty of the management has been discharged or not. So, looking at fairness, in order to ensure that any dismissal on the grounds of capability and on performance is not deemed unfair, we will have 5 key pillars that we are going to need to look at. And what they are is, as they are on the screen: an investigation, that the employee is being given an opportunity to improve, support and training has been provided. There has been a review of the performance, and ultimately, if the dismissal occurs, there is a right to appeal. So to go through them in a bit more detail, the first one I think is particularly important, and the investigation. Again, when I am comparing these to conduct issues and disciplinary processes, in practice, I think there is a general acceptance and understanding that any disciplinary process, there needs to be a fair and proper investigation that occurs before the matter is heard. I think that is less clear in the performance management processes I see. Again, we're going to touch on later in the session types of performance management, and we'll talk about performance improvement PIPs, and we'll talk about general performance management processes, and we'll talk about ACAS-led performance management processes. But strictly speaking, they all require an investigation. That investigation, again, if we're comparing it to a conduct issue, can be very different. Conduct generally black and white. There is an issue, something occurs, and therefore an investigation needs to be put into that issue. Obviously, with performance, often there isn't one issue. There is often a pattern of behaviour, and what we're needing to look at is that there is still an investigation into that. So this investigation is where a lot of your informal processes will kick in, and how you manage these individuals on day to day. So whether that is appraisals, whether that is performance improvement plans, whether that is general catch-up meetings, whether that's review of work, whatever you do, those meetings, those documents that you look at, that is critical to any form of investigation, because what the investigation should look at is those informal processes that you have in place, is what is done to review and monitor performance, to then obviously lead in to a more formal process. So if your documents are weak informally, that will obviously impact on the general fairness of the dismissal. So investigation often overlooked, but equally critical in performance management. Opportunity to improve, progress review can overlap, and obviously very, very similar in some ways. And often why, back to myself in practice, the frustration and the difficulty of performance management, because again, unlike a conduct matter, there needs to be, as coming from case law, employees need to be given that opportunity to improve, and that improvement has to be measured and reviewed. So what we are looking at is an opportunity, and again, we'll come on in a minute to talk about how the period of that comes over and how long you have to do that. But there needs to be a defined opportunity for that individual to improve. The frustration that we often see in performance management is the classic scenario of an underperforming employee. An investigation goes in, that's an identifier of the issue, and there is a first meeting, either formally or informally, and an opportunity to improve is given. What we often see is there is often a slight improvement, but this is short term, and it is not, it doesn't solve the solution. And this is why the frustration often comes in practice with performance management, because the process is often elongated by small and incidental improvements followed by a regression. So that opportunity to improve often is a source of frustration, but one that absolutely needs to be provided. Again, that then needs to be reviewed. The progress needs to be reviewed formally in terms of meetings. Support and training. Again, this is another frustration commonly with performance management, that support and training needs to be provided. So if we are, through our processing, giving targets, giving opportunities to improve, we also have to give the support mechanism there to help them, and if appropriate, training often is again, slightly in my understanding, misunderstood. this is support and training if applicable. So if someone is underperforming and there is no training need for, no reason for them to be underperforming, you don't have to provide training. So this is not a training is obligatory. It is the need needs to be looked at, and if there is a training need, that should be provided. But it's not a must, and it's not an obligation on the company. Final element of obviously general fairness is a right to appeal, which again we will come on to in due course. So, preventative steps. So again, we've talked about my views on performance management, but taking all of that into context, there are preventative steps that we can take that, even if we are looking at this quite in a black and white manner of we're getting someone to a dismissal, preventative steps are still incredibly important because it can help us get to a point quicker. So first element that is, again, very important in performance management is setting the standard. And this is elements that have come out of case law decisions from the tribunal. What the case law says is that employees have to be made aware of what the standard of performance is expected of them. So we, in practice, deal with all the time cases where the employee's defense through a performance management process is, I wasn't aware that I needed to do that, or I wasn't aware that I needed to meet these targets, or I wasn't aware of X, Y, and Z. Again, often the response is, you should have been aware, or we did make you aware. And again, back to the investigation point, that's why that is critical. So how do you set the standard needs to be critical and looked at with all employees, and this is something we're dealing with on onboarding, the start of the employment relationship. So generally, how are standards set? Three ways normally: either implied terms into individuals' contracts. So again, not to get into a too detailed contractual law presentation, the difference between implied and express terms. But again, I'll talk about express terms in a minute. But implied terms are terms that, irrespective of what's said in the contract, are implicit in every single employee's contract. So they are things that we call a duty of fidelity. That is to use their, to essentially use their best endeavors, to work obediently, to follow reasonable instructions. And that is implicit into everyone's employment relationship. And that, again, can set the standard when there are performance issues. Second issue we look at, again, which we've referred to, is express terms. So again, these are terms and duties that are expressed generally in the individual's contract of employment. So that is, again, in your contracts, are you specifying what people's roles are in the job title? Are we specifying duties? Again, job descriptions are important here, that can come in. Again, sometimes a question of whether a job description is a contractual or a non-contractual document, but in any event, important that we make the individual aware of what standard are we expecting of them, and what are their duties, what are we expecting of them if they then fall down. Final element, again, non-contractual policies, procedures, things in handbooks, in standalone policies that often, again, set minimum standards of performance. Final thing on setting the standard, again, that has come out of case law, that there are minimum expectancies. So some clients, when I go through that, then worry that a job description has to say absolutely anything, even if it's absolutely obvious. So the one we often use is, you don't need to tell an airline pilot that they shouldn't crash into the ocean. There are parts of jobs that the standard is obvious, that you don't need to share. and things that are the horrible word common sense as part of anyone's role. So you don't have to set the absolute obvious, but anything else, we need to set that standard. Probationary periods, again, often a useful time to measure performance. To be honest, as the brackets say, any time within the first 2 years makes life a lot easier, because again, we are not hopefully going to be challenged on the fairness of any dismissal. Again, I'm not going to get into discrimination, automatic unfair dismissal, but I think it's fairly obvious to everyone, the best time to deal with someone's performance issues is within their first 2 years of employment, or preferably in the probationary period. The point on probationary periods that are often missed is that obviously they can be extended. So if we are having performance issues in that initial 3 or 6 months of someone's employment, we can extend that. We can extend that period. Again, the key point often people miss is that if you are extending that probationary period, they need to be notified of that prior to the expiry of that period. So yeah, we need to be looking, diarising when those probationary periods happen. Appraisal systems, and then I put a series of exclamation marks. Appraisals, again, very controversial subjects in law, and going above that, the use of appraisals, and do they actually provide any benefit? Often what I'm seeing in practice is people are using appraisals, and then I would see an appraisal which says this employee is wonderful, this employee works hard, and it would be 5 out of 5 for everything they do. They then come to me a week later and say, we got this employee is underperforming. Well, why is your appraisal saying they're wonderful? And that kind of concern about offending people, the concern about saying to someone, this is not working out, is in that kind of often Britishness, often gets in the way of actual proper appraisal, and therefore again the link between appraisal systems and performance management processes need to be questioned. The other thing we see in practice a lot is individuals using an appraisal as a formal performance management meeting. So when they are going through a process, they're saying, we've met with the person to discuss their performance, here's their appraisal, here's their 6 monthly appraisal. We've told them they're not performing, therefore we're now going to dismiss them. Obviously, an appraisal is not a performance management process. It's not a hearing that would be classified that as that. Yes, appraisals can be used. That investigation, again, point is critical on appraisals. Use appraisals to feed into the investigation, but it's not a replacement to the process. Again, early intervention. Often this again is self-explanatory and can go against what I'm going to come on to the relevance of performance management as a whole. But if we do have issues with performance management, I think it goes without saying, the earlier you tackle it, the better. When we are seeing this in practice, it is often, how long has this been going on? Years is the answer we're given. So again, it's not going to fix itself. And if there is no other route that we're going to talk about, yes, it's better to tackle it immediately. Obviously, if it's in the first 2 years, even better in terms of a process to follow. Again, the advantage of doing that, as we said, if there is a turnaround, it's going to happen early. If we're looking at it early, that's the court will look more favourably at that. It gives us opportunity to put processes in place. We are confronting the issue. Again, you get criticism, you see criticisms coming out of the tribunal where performance issues aren't aren't met and considered by the company for a number of years. So the question for the tribunal is, well, if this is such a big issue, why was it not addressed 2 years earlier? Supportive approach, again, it's back to this semantics of performance management. Do people respond well to being called incapable? Unlikely, but equally, you need to confront the issue. So again, take that one or leave that one. Obviously, we don't want to be rude and we don't want to upset people, but there needs to be a balance in how we're dealing with that. So if we get to that process that we have done the initial investigation, we've gone through that, we identify that there is a performance concern, how do we deal with that? So again, what we are looking at here is now a formal process, and I'll come on to later. There's a number of ways to, in essence, skin a cat, and people have different names and different processes within a formal performance management process. So some organizations use a performance improvement plan, some use a more formal process that would more closely resemble a disciplinary process under the ACAS code. So yes, even with performance management, we do need to comply with the ACAS code. But again, to stress, this isn't a disciplinary. So what do we need to do with a formal performance meeting? So again, obviously there needs to be an invitation. So once we have identified that need, we then have to have a meeting. What that will involve is obviously inviting that individual to a meeting, which sets out obviously some of these key points, the nature of the concern. So what is the performance issue here? So again, the more detail, the better. What exactly is the performance issue? So the kind of letters that we see are criticized. We call you in a meeting because to discuss your poor performance. Well, what is it? What are the precise concerns about performance? And then obviously, which critically goes along with that is the evidence. So again, going back to the investigation, what evidence do we have of that poor performance? That needs to be shared in the letter inviting them to a formal performance meeting. So they need to be aware of that, obviously, so they have a right to respond to that evidence, because obviously in practice, what a lot of you will have seen when you've done these meetings is often the evidence does get challenged. Well, your rota misses this, or your stats don't show this, or I've done this, or the reason my stats are low because I'm doing this. So evidence is critical, but obviously the evidence needs to be robust and allowed to be challenged, which brings you on to often the next point, which is the response and feedback. So within that meeting, an individual does have a right to respond, a right to request further information. They can offer legitimate reasons. They can offer mitigation, which we need to consider. So again, this is where we get into other areas of the law, but we can look at ill health, we can look at stress, we can look at anxiety. Once we have considered that, we are then going to make a decision. And what will come later is potentially that decision will be accompanied by a warning, or actually what we normally call them in a capability setting is an improvement notice. Because again, we are distinguishing between a conduct issue and a performance issue. So when we are responding, again, in writing, we need to set targets that the employee can achieve. Again, those targets, if possible, can be what we call SMART: specific, measurable, achievable, realistic, and time orientated. Again, this is where performance improvement plans are very good at this and set out. Timescales, again, for improvement, those timescales need to be reasonable. So we're not going to say you've got 2 days to improve. This needs to be probably a matter of months to improve. Training and support we've talked about that needs to be provided. A warning needs to be given, or as I say, an improvement notice, which will come in a part. And obviously, as we said, those decisions need to be communicated through a letter. which obviously gives a right to appeal, not just the dismissal, but any sanction that follows that meeting. So a bit more detail about warning and time scales. Review periods, again, often one of the questions I get a lot is, well, how long is a review period, and how long should it be? Unfortunately, we give the classic lawyer's answer here of it depends on the facts. So it is often fact sensitive. We look at areas such as, well, how long has the employee been here, their length of service, what job are they doing, the importance of that job, their seniority. We're looking at how serious is the underperformance, and therefore how quickly it needs to be resolved. And then we're looking at the context of what they do. So again, if they're in a sales role, if they're in a fee earning type role, which is measured monthly often, again, those are relevant periods. So the period should be relevant to what that person does. So any job that's cyclical, we're looking at review periods to kind of reflect that. Again, question in terms of performance, kind of underperformance and incapabilities. Can we have a single act of performance which would justify a dismissal? The official answer is yes, but in my years of profession, I've not yet seen one. So we can have gross incompetence, and which would obviously amount to negligence. Where you don't see a lot of them in practice, because again, this is where there is a blurring of the lines between someone's conduct and someone's capability. And there are sad lawyer arguments that we sit around a table and argue, well, is someone's gross negligence a conduct or a capability dismissal? My view is the law probably says it's a capability dismissal, but they're generally dealt with as a performance issue, because the neglect often results in quite catastrophic issues, and it's often dealt with as a conduct issue, and there often is an element of conduct which goes with the negligence. But strictly speaking, yes, if an act is so is so gross and is so potentially negligent, yet one act can result in any dismissal. We still need to look at, can that be rectified, the performance, the training, the support that we talked about, but it is possible. Equally, warnings or improvement notices, can we just have one? So just as we can with conduct, we can on occasion go to a final written warning. Can you go to a final improvement notice? Again, the answer is yes, if the performance justifies that. So if the underperformance again is more than either a trivial or more than a regular issue of underperformance, we can go right straight to a final improvement notice. Again, we'll turn it absolutely on the facts, and those levels of review and support will need to again justify. I think for me, if you're going straight to a final improvement notice, how long we review it may need to be considered. So the seriousness of it, say, comes back to the review period. Performance improvement plans, I'll just touch on. Again, there's often a misunderstanding that performance improvement plans are something different to a formal performance management process. They're not. Again, it's often a question of semantics and organizations thinking that so calling something performance management is often has a negative connotation. So performance improvement, the theory is that has there's a greater mutual obligation on the employee and the employer to improve. The major difference between PIPs, performance improvements, and a more traditional form of performance management often is that informal stage that we've talked about. That rather than traditionally where there are an investigation occurs, an underperformance is found, and a hearing is held, that a performance manager, a PIP, will have a greater formality of when that performance issues arise, that they will be reviewed initially, and standards will be set to help them improve. I know organisations who use PIPs with almost all employees, so that they would run them from the start, even when there is little or no underperformance, in a way of that we are looking at everyone's performance from the start. So no great difference ultimately with a PIP. You are still going to need to follow that formal process when you are starting to look at improvement notices or warnings, and that process needs to be followed. But again, a useful tool that a lot of organisations use. So if we get through and we've gone through a process of warnings, ultimately that leads you to a termination meeting. Again, the process is the same in terms of getting you to that meeting. So we have gone through steps, and these individuals are on final improvement notices, final warnings, and we need to get to potentially a final meeting. So the process needs to be followed. We still need to obviously write and inform. We still need to investigate them. The only obviously key in the difference when we are in inviting them, we do need to warn that a potential outcome will be their dismissal. And that needs to be set out in the letter. Obviously, the letter needs to summarize the position, so that, again, we can't just work on what the latest issue of underperformance is. It's let's go back and review the whole process where there's been underperformances, the reviews, and that is all set out, and those concerns are set out. Again, the hearing then needs to take place. It's not fait accompli. We still need to give the opportunity, the same opportunities to raise mitigation, the same opportunities to comment on the evidence, the same opportunities to explain where there may be underperformance. But the process there is obviously they need to be informed that a dismissal may occur. Obviously, when we have a finding, that needs to be communicated by letter, and there needs to be a right of appeal. Alternatives, and again, there's an old case that we're going to reference, but again, alternative employment is often something that is generally looked at in redundancy processes, but there is sometimes obviously can apply to performance management. Again, personally, I struggle to see the logic in making a finding that someone is incapable of performance, but then any motivation to find them something else that they can potentially underperform. But there is a case that says, obviously, in Sonvardi and Superdrug, where an employee was fairly dismissed when his employer concluded that his failure to communicate to the staff and motivate them made him unsuitable for his management position. They did not consider demoting him to an assistant managers because the same concerns would have still been apparent, and the tribunal accepted that. So again, a helpful case that says, because it sometimes is raised, that, well, can I do something else? Well, probably not, because your performance concerns that you had as a manager would still be there in a more junior level. Other alternatives, obviously, the next 2 points are absolutely critical points to kind of finish on today. Settlement agreements. Anyone who has dealt with me in practice would, or most lawyers would know that the settlement agreement is the employment lawyer's best friend. So these are something that I would recommend if we are going through a performance management process, ultimately to look to dismiss someone, and that we're pretty confident that will happen from the outset. Offer a settlement agreement really any time during the process and probably before it, because what I think we'll have got from today is the length of time often involved in performance management. I'm sure, again, if I was delivering this seminar in person, I'd often ask for contributions as to how long they've gone through this and what's the, we often have, what's the record, how long have people gone through this, and it can be years and years going through the same issues. So again, what we often would say, look at this commercially. If we know this process is going to take us 6 months to get through, well, can we have a conversation right off the bat that says, unfortunately, this isn't working out. We have some performance concerns. We are prepared, and we will look at this through a formal process. However, we'd like to make you an offer to mutually terminate your employment, and that will be based on and offers of 2, 3, 4 months. Salary can make a big commercial saving in the end. So settlement agreement, again, look at or as a real key alternative. The final point, as this still relevant, can we find another reason? And again, I'm trying hard to not seem brutal and militant here. And again, it is not my intention to say that what we're looking at here is dismissal and that employees can't improve. Absolutely, let's hope they can. But obviously, in practice, we are often finding there are issues, unfortunately, where there is this is ongoing. So is there any other reasons? And again, this is not to say that any dismissal is predetermined, but there's 3 I've mentioned, but the 2 main ones that we see. Obviously, performance, capability, and conduct, there is a massive overlap. And what we would often look at right at the start, if we are addressing performance concerns, is, well, actually, is there any form of misconduct here? The classic scenario here is often a failure to follow instructions. And there is poor performance. And yes, there is an issue that someone has not done what they're supposed to do and that they're aware of what they're supposed to do. But equally, if they've been told directly by their manager, supervisor, to do something and they don't, that can go down a conduct route as well. And then, so we need to always be aware in these scenarios, well, is it conduct? Is it capability? Possibly it's both. I again would hesitate to recommend people following dual processes. It often can look desperate. But ultimately, if that is what the facts presents, equally we see issues of companies getting away down a performance management process and then switching to conduct. And again, this is where it's really important not to blur the lines between improvement notices on a performance capability process and conduct warnings. So again, we've seen cases of people being taken down a performance route, receiving things that are called final warnings for their performance. There then is an issue of misconduct, and then they're dismissed, not on the grounds of a gross misconduct, but the fact that they've received a final warning or improvement notice for their performance. And again, really important that you are on the correct path, and those paths don't mix. Redundancy, again, something that we can look at. Underperformance often can be in scenarios where people are not motivated or busy, or the requirement for their role changes. So again, if you're in that scenario of someone underperforming a role that is changed or is not particularly well scoped, or the needs of the business have changed, well, actually, is this a redundancy situation? Can we look at this as a redundancy rather than a performance management? SOSR, again, very, very fact specific, as we talk about some of the substantial reason. These can come in issues where performance is masking another substantial issue. This is often the case where there is either a personality clash or a clash of cultures that is meaning that essentially the relationship is untenable. I wouldn't be using this presentation as an invitation to now go and dismiss everyone by the grounds of SOSR. Tribunals are very reluctant to look at SOSR as a front and centre reason. It is often better used as an alternative to another reason, but again, potentially can be used when there is a performance issue that's masking something else. So to finish, just on a kind of conclusion for today, key steps in performance management. So again, communicate standards from an early stage. What do we expect? So we've talked about implied, expressed, and non-contractual policies, setting that standard. Again, review the documentation that you've got, reviewing these probationary periods, keeping them diarised, reviewing your performance management processes so we know what we're doing. Again, are we following PIPs? Are we performing other forms of performance management? Confront it early, preferably in the first 2 years of doing so. Make sure that any targets for improvement are SMART. Again, PIPs come into this, but any targets set in performance management need to be measurable, and they need to be a way that can be objectified. Finally, consider ongoing training, supervision, and time to improve. An obligation, it doesn't have to go in every case, but we need to at least consider that supervision and then critically that time to improve. How long that improvement should be over, again, relevant to the facts of the case that we're using. Make sure you follow the code that you use, contractual procedures or PIPs. Again, organizations get themselves in trouble where they have fantastic documentation that sets out quite a lot of obligations on them, very fancy PIPs that they have to follow, and then they don't follow them. You're better not to have one and have a more structured process than have something that puts a lot of obligation that is not followed. So make sure you're following your own procedure, otherwise that you'll be criticised. Administer warnings, or as I said, really we call them improvement notices, where appropriate. Consider, again, probably more than one warning or one improvement notice is the advice, apart from exceptional circumstances. Separate out personal. Again, we're not really touched on this, but again, it's what we've talked about, that this is a very emotive subject. Focus on the poor performance rather than the personality. Again, personality clashes, what I will often see in practice is, Sam, we don't like their attitude. Sam, they don't fit in. Sam, they're a bad egg. Again, separate out the personal. What is the poor performance? What is it? Identify where your evidence is there, and obviously to consider alternatives and do that straight away. The advice is don't wait till the end to look at alternatives. We can be grown up and understand that someone's poor performance someone can be allowed to improve, but we're going to consider dismissal at an early stage. What are those alternatives? Other potential grounds that are fair? Settlement agreement, obviously being the key ones there. There is generally always an alternative, and therefore we look at the starting point. Is performance management still relevant? The absolute answer is yes, but be wary and don't go through a performance management process unnecessarily. They are incredibly complicated. They are incredibly time consuming. and we need to make sure if we're doing it for the appropriate reason, and we are willing and able to see it out to the end. So always look at alternatives early, because there may be a better one. But if not, we know what the process is. We know what to follow, and make sure that we are following that process. And important, that 6th point, follow your own process. So if you've set one out, make sure you follow it. So that is it for today in terms of performance management. Again, I just finish really where I started, that this is the first of a series of events. I haven't listed them on the slide because there's a number of them. Best place to look is on the website. I know a number of you are obviously on our mailing list, so you'll be getting our Monday morning dispatch every Monday, which obviously sets out the seminars as well. Obviously, anyone that you know that you think might be interested, please forward that on to them. If anyone is not part of the mailing list and would like to come on it, it's an update we send out every Monday, summary of the law, the case law, what's happening in the world of HR and employment, and obviously details all our events. So their email is on there, employmenthub@chadlaw.co.uk. Any emails go to there. Any interest in any events, drop us a line. Go on the website. I'm just going to stop sharing my screen. I don't think there is anything in the chat, which is fine. Anyone that does have any questions, as I say, please drop us an email, a team an email on the Employment Hub email. Finally, for me, is a big thank you. Obviously to absent friends at Hayes who unfortunately couldn't be here. They will be here at the next event. Big personal thank you to my team, especially Kira, Jake and Phoebe, who helped me with this event. Hopefully, again, an event that is being useful. I hopefully will see you all soon. There are plans that we may return at some point to doing these in person, which I will counting the days. It would be lovely to see your faces and to ask questions and make this more of a participation event. Otherwise, I hope you have a lovely day, and I'll see you soon.